What is the Court of Equity? Is equity part of the legal system? Prior to the founding of the United States, the court systems were the court of law and the court of equity. And going way, way back, without getting into too many details, essentially the court of equity was run by the church and the court of law was run by the government. And if somebody couldn't get justice in the court of law, they would have the opportunity to go to the court of equity to see if they can get justice there. And because the religious authorities had so much weight and authority in society at that time, the court of equity was respected and followed by many, if not most, people in society. And unfortunately, people often couldn't get justice in the court of law. Maybe they lost on a technicality. But the court of equity looked at what is inherent justice in the situation, what's the right way to handle this situation, rather than what is technically the law and did somebody follow all the technicalities. In the United States legal system, we have merged the court of law with the court of equity. I'll tell you a little story. There was once a judge appointed by Ronald Reagan who handled a huge case in the United States. And I don't want to identify this judge because I don't have his permission. So I'm going to keep the details brief. But a very large case, and the judge issued a ruling that was extraordinary in the minds of all the experts who were following this case. In fact, I spoke with a number of the experts, and they thought that the judge's ruling was absolutely not in accordance with the law. Well, I asked the judge about this one time. I had an opportunity to talk with him. And he quite simply said, I was sitting in a court of equity. What he essentially meant was it didn't matter what the law said if the outcome would have been unjust. Operating within his authority in the court of equity, he could bring about justice to the situation regardless of whether the statutes would accomplish that. Now, that was a fairly bold decision. Judges can get in trouble and occasionally even overturned when they deviate too much from the law. But this was an Article III judge, which means the judge was appointed by the president. And the judge determined he was well within his authority to make that decision. And by the way, it turns out he was. The case was appealed, and that particular aspect was not overturned. What's the point here? The point is that it's not enough to win on a technicality in court. You also want to appeal to the judge's sense of justice or the jury's sense of justice if you have a jury. A great litigator who's no longer with us once told me, when you go to argue your case in court, remember that judges are made up of both hearts and minds and argue to both of them. In other words, go ahead and argue the logic and the reasoning to the mind, but also you want their heart to want to support you as well. So it's important that justice be on your side and you explain how that is. Being attentive to both of those pieces makes you a great lawyer. So, what is the court of equity? It's essentially the idea that even when the laws don't have a just outcome, courts have the authority to bring about justice in extraordinary circumstances because of their authority in the court of equity. All right, that wraps it up for today. If you are interested in being notified about future live sessions, usually we send out a notice a couple days in advance. You can get that notice in two ways. You can subscribe to this YouTube channel and turn on notifications, or you can get our emails. To do that, go to aaronhall.com/free, enter your email address, and you'll know about these free live YouTube sessions, and you'll also get access to exclusive videos that aren't available to the public. It was a pleasure having you here today. I look forward to seeing you next time.